Associate Dean for the Environmental and Energy Law Program here at GW. I'm really pleased to be able to welcome Randy Abate to our school. Randy and I have probably known each other for about a decade now. And Randy has sent us, when he was at Florida A&M, sent us some of our best graduate students, LLM students. So we're always have been very appreciative of Randy's involvement with GW. He's now the inaugural Reschnitz Family Endowed Chair in Marine and Environmental Law and Policy, and professor of in the Department of Political Science and Sociology. It goes over on the back side of his card, at Monmouth University. So he comes to Monmouth after several years of teaching in law schools, and now he's teaching in an undergraduate setting. He's spoken and traveled all over the world, in Argentina and Australia and Brazil and Canada, the Cayman Islands, China, India, Kenya, Kyrgyzstan, and had a Fulbright specialist grant in Odessa in the Ukraine. So he's got a lot of interesting international experience. He's going to talk to us today about climate change and the voiceless, a passion of Randy's work now. So please welcome Randy Abate.
Thank you very much for that very kind introduction, Lee. It's great to be here at GW, especially now that I'm here. I drove from northern New Jersey today. I won't be doing that again soon. So it's, as Lee mentioned, a real passion of mine to speak on these issues, particularly on this subject, because it couldn't be closer to the heart. This is a book project that I've been working on for the past close to 9 months now, and it's due in 10 days. So the manuscript is literally being fine-tuned as we interact today, and for that reason, I really welcome your input, your comments, your questions, your criticisms, anything you have to say. Just don't make me rewrite the book, but any of those little tweaks would be much appreciated, and I always approach any audience, especially at a school like GW, with I have more to learn from you than you do from me, so I'm eager to make this as interactive as possible. I encourage you to ask questions if they're burning while I'm going through, especially if you know you have to leave earlier. I want to get your input. My cards are on the table, so I do want to be able to keep in touch with you if you want to communicate about any of our discussion today afterwards. So the topic, as you see, in general, brings together three worlds that aren't often in the same breath. So to give you a little context, a prior book project from a few years ago I put together was, what can animal law learn from environmental law? So I started down that journey of looking at ways in which two of these three pieces intersect and ought to work together more effectively. And then another side of my work is climate change for more than a decade now, and more recently climate justice. And a big focus in climate justice these days is protection of future generations. And so to me, I started thinking more about, well, it looks like there might be three categories that belong under the same roof when we think about climate justice as a plight for those who are yet to be born and facing challenges as a vulnerable population. And then wildlife and natural resources as similarly vulnerable under the law, and yet with growing movements to protect them through various legal mechanisms, which I'll talk about in this presentation. So I invite that pushback of these three things don't seem to go together and never will. That's the kind of input I like to hear, because this is something that is new and as you know, in progress. So I want to give you some context of what I want to address, and again, please feel free to interject on anything that doesn't make sense or you want to share. So I want to give you a sense of context from, and DC is no better place to do this, where so much of our environmental law legacy has been grounded. I want to take you through the three different periods that I see of environmental regulation, both within the US and internationally, and what significance that evolution has for an opportunity to protect what I'm calling the voiceless, these three categories: the future generations, wildlife, and natural resources. So I'm going to offer some suggestions about how do we move to this new paradigm, and I'll tell you what the paradigms are in a moment, and then provide you some context on current developments. I want to make sure we're all reasonably on the same page about what has been happening just in the past year alone in terms of judicial developments, legislative developments, across all three fields. And some of them don't seem to be aware of each other because they're really not. So at the end, I want to propose how the law can bring these three categories together in a way that would advance the protection of all three, and it's done in the context of confronting our climate crisis. So, as you know, there's quite a bit in the news about efforts underway to address the climate crisis, most recently discussions of the Green New Deal. And so this is another dimension of respecting the urgency that the climate change crisis presents and how one way among many the law can respond to more effectively protect resources, wildlife, future generations, and of course the rest of us as well. I'm not forgetting that part. It reminds me of when I tell people I'm an animal protection advocate. They say, "Why do you hate people?" So it's not an either-or thing. I'm very much a proponent of what's happening globally and domestically, whatever we can to address climate change through traditional mechanisms that are human-oriented. And then these protections are also valuable. And I don't see them as a one or the other proposition. So one thing that I'm sure many of you in the room understand is that our system of environmental law in the US is not a tree hugger legacy. It doesn't mean it's not good. It doesn't mean it's not effective. But the foundation of our environmental protection system is very anthropocentric. And that's something that I want to take you through as we go to where we are today, or potentially where we ought to be. So basically, the foundation of our federal environmental laws were based on human health protection. The revolution, if you will, in the 1970s of major environmental statutes that came out of Congress, Clean Air, Clean Water, Resource Conservation and Recovery Act, NEPA, and the Endangered Species Act, I'm going to set aside for the moment. But the traditional command and control environmental laws were all focused on this idea of pollution is a problem, it's bad for the environment, but we're going to actively regulate these problems because it's killing us. And that's really what generated the momentum behind these laws. They were human health focused laws to address different forms of pollution. So ultimately, that legacy continues to today, and it has been very effective. The US continues to be a model for many other nations with these laws and how they are effective in protecting human health impacts of pollution. The problem with the model, though, is that ultimately much of the regulation was proceeding from a paradigm of the resources are there for our use. So it was always a standard of, well, I shouldn't say always, often a standard where it was how much pollution of the resource are we going to tolerate, not we're not going to pollute that at all. So there are many examples of that, whether it be traditional environmental law or natural resources law, where that is the approach. And so that's something where I suggest that these two laws offer an opportunity to be different in how they approach regulating environmental issues. And they offer some opportunity to build on with how we move forward. So basically, the Endangered Species Act is one that's often considered separate from the rest of them in how ambitious it is, how eco-centric it is. It's not driven by human health concerns the way many of the others are. And how it really is something that treats nature as having intrinsic value, particularly wildlife in this case, but also the ecosystems on which they depend. So that's what I'm referring to when I start to talk about this ecocentric paradigm that we need to move toward. It's very much what the Endangered Species Act embraced. And then NEPA is an example, the National Environmental Policy Act, of a statute that was effectively based on the sustainable development paradigm. And that's something that's still a work in progress, and that's something that I'm arguing we need to take more seriously about. I'm going to show you the actual language of sustainable development and how it really embraces all three of these categories that are the subject of this talk. And so NEPA provides a model where look before you leap. And it was narrowly focused on federal agencies and major federal actions. But the concept of you're going to think about what you're doing before you engage with the environment in a potentially harmful way is also a valuable regulatory model, coupled with the highly protective ecocentric approach of the Endangered Species Act. So I wanted to just share that with you at the outset, the traditional anthropocentric approach and these two exceptions. So that's really the first era, highly successful laws that were pollution control oriented to protect human health. And that worked very effectively, 1970s, 1980s. By the time we got to the end of the 1980s, there was a growing awareness of that not everybody was getting the same degree of protection from these environmental laws. And so a movement that became coined as environmental justice began, and it was initially focused on African American communities, how time and time again, a study was conducted in the southeast region of the US that these undesirable environmental impacts were almost always located in these communities. So if it was going to be a landfill or a hazardous waste facility or heavy industry, you often found African American communities living very close to these facilities. And so the law ended up developing a response to that reality known as environmental justice, which was a growing awareness of protecting the vulnerable. That environmental law can't just be this goal of protecting the environment for most. And so that evolution from traditional command and control to environmental justice then evolved into climate justice. And again, the idea was protecting the vulnerable, that environmental problems are going to affect some communities more severely than others, sooner than they affect others. And ultimately, there's going to need to be a way for the law to respond to that. And that's a challenge, and that's an ongoing challenge that we see both in the US and internationally. But it did mark a transition from the paradigm that there had to be a growing sensitivity about how environmental law worked to accommodate these vulnerable populations and protect them to the maximum extent possible. So from there, there is now a movement that I'm going to be talking about, well, a couple of different movements that are focused on protecting these categories of what I'm calling the voiceless. And there's a body of law, judicial decisions, legislation that goes along with each of these categories that's currently happening now. One thing that I'm going to be adding to that, so basically, visually, we have three silos, the current state of the reality here with protecting future generations. We've got a lot of climate justice cases involving the youth plaintiffs in the US and all over the world seeking to protect themselves and on behalf of those not yet born from climate change impacts. Wildlife is an entirely separate domain, and we've got traditional animal law involved in this silo, and then we've got other developments with respect to species. And then there's natural resources with the rights of nature movement. So one goal of the book is to make the three silos aware of each other, how they are in this together, number one, and how working together through a common legal paradigm can help all three and what they are seeking in the way of legal protection, and could be a leverage point for society to address climate change. So basically, we've been aware of climate change as a crisis for many, many years on many levels, but we are at a point now that's almost what the science calls a tipping point, but I call it a tipping point in terms of the regulatory options that we're facing. We're getting more and more dire news from climate scientists about how little time we have to meaningfully act to address climate change, how the impacts are projected to be more and more severe, closer and closer to the present. And of course, without any legal protections in place for these voiceless communities, they are by far the most vulnerable, more vulnerable than the minority and low-income communities that are already getting some attention. And what's in it for us? We're the regulators. There has to be something that makes sense for us to protect those who cannot speak for themselves. For the voiceless to be protected effectively builds a resilience across society. So we want healthy natural resource systems. We want healthy wildlife species in their ecosystems. And ultimately, we want to have a set of yet to be born members of society inheriting a habitable planet and not just running and hiding and engaging in damage control. So all three, to the extent they're effectively protected, is a valuable opportunity for responding to climate change. So this just summarizes the three boxes that I've talked about and how the ecocentric era is where we're starting to nudge toward with these developments that are happening in the three separate silos of the voiceless. So the previous slide made reference to stewardship and rights. I'm going to talk more about that. But basically, my view of the ecocentric era has two fundamental components. It is a demand for more government stewardship, and we're seeing that in a lot of the climate justice litigation. So the Juliana case being one example in the US, where part of the plaintiff's argument is that the federal government has a stewardship responsibility to protect the US citizens from the harms of climate change. It has a duty to regulate when it has chosen not to on that basis, and another basis, which is the rights part. So the rights part of the Juliana argument is very much of part of the paradigm that I'm proposing, and that is imposing or advocating for the government to have greater stewardship responsibility is only going to be so effective without a way to enforce it, without a way to say, you failed to do it, and we can respond by demanding, compelling you to do it. So rights-based protections are incredibly important for this whole approach to work, and that's part of the Juliana case's argument as well. This notion of a constitutional right to a stable climate is another piece of that argument that the youth plaintiffs have brought. In addition to saying the government has a stewardship duty to regulate climate, that's the kind of top-down idea. The bottom-up idea is the plaintiffs have a right to inherit a stable climate, and that's essentially a constitutional argument that's being made under our due process clause. So what I love about that advocacy, and the only thing that enables me to wake up each morning as a beaten down climate change advocate is the idea of how creative these theories are and how effective they are already becoming. So one thing that I love about the Juliana right to a stable climate argument is that it's building on precedent from a same-sex marriage case. Who would have thought to combine those two theories? So the Obergefell case from the Supreme Court just 3 years ago had reasoning in it that said, we're going to identify the right to same-sex marriage as a fundamental right because marriage is so essential to society. It's a platform to the enjoyment of many other rights. So it would be quite harmful to say you don't have a right to enjoy same-sex marriage because you would essentially be deprived of so many other rights the Constitution guarantees you. And advocates for this case and Judge Aiken, who heard the trial court decision a few years ago in Juliana, agreed that building on that logic, we similarly ought to have a right to a stable climate, because if you don't have a right to a stable climate under the due process clause, the rest of your guarantees are pretty much meaningless under the Constitution. You can't do much when you're dead. So ultimately, that's very compelling analogy by reasoning that took a lot of creativity. There's also a piece to their argument that's talking about children as a protected class for an equal protection argument as well, which is similarly creative, and that has potential to succeed as well. So how do we move to this ecocentric paradigm? Ultimately, there's a lot of momentum. And again, this is what I find very heartening. It's not even close to a victory every day in the courts, don't get me wrong. The climate justice movement is hard work. It's taking a very long time, but the fact that it's a movement is very encouraging. The fact that we just don't have a series of cases, most of which lose in the courts, the fact that climate justice cases have given rise to this thinking that climate justice is something all of us need to value, and it's going on in the halls of Congress and throughout state and local governmental levels. That's part of the leveraging that we need to do. There's already thinking in this manner about the need to protect future generations through the climate justice movement. And then there's also some gains that are being made in the wildlife domain, particularly in lawsuits brought by the Non-Human Rights Project. And this is seeking legal personhood for animals. And I'll talk more about how that's a valuable source of leverage and momentum for this proposal. And then the idea of collaboration across these three disciplines that are related in some way, but in many ways doing their own thing in their own lanes. That's going to be very important as a way to promote long-term resilience and also to protect vulnerable populations that need these legal protections. Oops. So that's the best I can do as not a graphic design kind of guy, in the sense that climate change is this unifying force in a couple of ways. Climate change presents a form of uniform vulnerability for all three populations, and also presents an opportunity to say we need to advance this ecocentric thinking for the benefit of all three because of climate change, because climate change is presenting an urgent crisis, because we're looking for a way to justify regulating it more aggressively. These connections that can be drawn as a common framework of vulnerable populations can be powerful as a tool to make climate change regulation happen sooner and more effectively. So just some brief comments about where things have been in the climate justice world on the future generations side in many ways. Talked about the Juliana case already. That's been a bit of a model for many others that have started around the same time or afterwards, and not surprisingly, many more positive outcomes outside the US. The US court system is very experienced with these kinds of issues, but the track record on climate justice cases is hardly any of them have succeeded. If they have, they've only succeeded at the trial level and were reversed on appeal, either at the circuit or Supreme Court level. Whereas outside the US, Urgenda was just a glowing example of how much is possible when we look at the urgency of the climate crisis and how the Netherlands is not a climate laggard when we talk about climate regulation. Here's a country that was doing what they were supposed to do under the Paris Agreement. They were sued by a group of plaintiffs that said, you're not doing enough, even though you're doing what you said you would do, because science is now telling us you need to do more. I mean, even as a green conscience kind of guy, I was like, wow, that's ambitious. And they had so many different legal theories as to why they were entitled to this relief, to command the government to do more than they committed to do. And they won on all of them. They won under Dutch law. They won under EU law. They won under EU human rights law. They won under international environmental law. So that the victory in that case at the district court level was my first, oh, I shouldn't be so skeptical. But then it got appealed and I said, okay, yeah, now we're going to get the reality check. And it was upheld on all those grounds on appeal too. So that's very encouraging. There are similar cases going on different theories. And we're starting to see some successes, but many of them are still pending. Colombia was another example of a big success. So there we had plaintiffs, youth plaintiffs seeking to have reduction in the deforestation rate that's contributing massively to climate change in the Amazon. And that case succeeded. Not surprisingly, in any developing countries, enforcement of the positive order is always a big challenge. So that is a work in progress in Colombia. They got a great outcome to compel the government to reduce the deforestation rates, but enforcing that outcome is a challenge. We're also seeing suits against the private sector. So again, the interest in habitable climate into the future isn't just about blaming the government for everything. We've got a private sector filled with multinational corporations that are doing a significant contribution to global climate change. Some of these lawsuits in the US were brought against a group of about 24 multinational fossil fuel corporations. Collectively, I believe they represented about 20% of global greenhouse gas emissions or carbon emissions, which was just shocking. So that's also a good target for these kinds of lawsuits. This one in the Philippines Human Rights Commission, it's a human rights basis for the suit. Basically, the contributions that these corporations are making to global climate change, how they're causing human rights impacts as a potential foundation for being an actionable claim. This is an iconic photo. So all you have to do is type in monkey selfie on Google, and this is the famous case involving a monkey in Indonesia that took a photographer's camera and snapped some selfies. I mean, that's better than any selfie I've ever had. So that's a remarkably good photo, and it was an advocate from PETA, People for the Ethical Treatment of Animals, that sued, arguing that this monkey should have the intellectual property rights to those photos that were taken with the photographer's camera. So in many ways, those kinds of cases get a bad name. They get accused of being frivolous litigation, a waste of the court system's time. Not surprisingly, this was not a successful claim because the monkey was not recognized as having legal personhood to be able to have intellectual property rights under the act at issue. But ultimately, it was a very important public awareness campaign kind of case, and PETA is well known for bringing those. I don't see them as frivolous. I see them as advancing the law. I see it as strategic litigation. And so the cases at the top of that slide are the ones that are getting even more attention from the Non-Human Rights Project. They're bringing cases, again, pushing the envelope of establishing legal personhood for animals. And remember, those of you who aren't familiar with the concept of legal personhood, it's not making animals more like humans. All legal personhood means is who matters under the law. So we already have recognition of corporations and ships, and as we'll soon see, natural resources having legal personhood. So it's not so outrageous to think about animals having legal personhood, particularly when you see legal personhood for natural resources. I mean, rivers don't have sentience the way animals do. They don't communicate, they don't experience emotions the way animals do. So these arguments are being brought through habeas corpus, seeking the release of chimpanzees from confinement. And really all legal personhood means for their domain is freedom from confinement, freedom from suffering against their will, and seeks to have them released to sanctuaries where they are much better able to thrive. Those cases have not yet won. The most recent one was brought on behalf of Elephant at the Bronx Zoo, and that actually, there is a show cause hearing underway for that one. So that one's close to getting somewhere, which is very encouraging. But ultimately, these cases seeking personhood for wildlife are an important way of growing the awareness of the way the law can protect these vulnerable populations. We're not just talking about vulnerable people anymore. We're talking about vulnerable populations that have no voice in the legal system unless we decide to give them one. And there was a successful case in Colombia that was initially prevailed, but was reversed on appeal on the same idea, habeas corpus claim. So in the rights of nature context, a lot is happening all over the world. Many positive developments here, again, but not in the US. So in the US, the unsuccessful litigation so far was a fracking case in Pennsylvania. There was an effort for a watershed that would be affected by that fracking operation if it proceeded to intervene in the case as an interested entity that was part of this dispute. And that intervention request was denied. And more recently, a case involving the Colorado River, seeking legal personhood for the Colorado River. That attorney who I interviewed for this book is understandably bitter. Not only was that case not allowed to proceed, but he was threatened with sanctions if he didn't voluntarily withdraw the case. You talk about bullying your way to thinking, getting bullied into how you should think on a given issue. So, whereas you look outside the U.S. and we're seeing remarkable developments in India. The first one came in New Zealand, where legal personhood for the Wanganui River. This river is going to be managed by a guardianship arrangement with the Maori tribe, and they have a very close relationship with that river. They are obvious choices for being the ones who speak for the river now that it has legal personhood. Ganges River was a similar development that was not connected to indigenous communities representation. And the Atrato River in Colombia as well, also recognized with legal personhood. In that instance, by the court itself, in a sua sponte way, recognized the legal personhood of the river there, which is quite encouraging. So I want to bring this back to the initial point about sustainable development. Sustainable development is a term that we've thrown around for more than 30 years, developed in the late 80s. And if we look at just that definition that we've been working with since the 80s, that language is relevant for all three of these categories. So the word future generations appears right in the definition. So certainly that category of the voiceless is embraced by what sustainability should mean. And the idea of meeting the needs of the present without compromising the needs of future generations, what does that mean if not the way we use resources, the way we engage with wildlife? This is what is a big piece of what it means to be sustainable or not. How we're using resources. Are we just depleting them without regard for their future use, or are we doing it in a way that says it has to be done sensibly with a recognition of that principle? So that is, in many ways, sustainable development has only been aspirational rhetoric. It appears in a lot of soft law documents. It's a kind of a lofty goal without teeth in many ways. It does appear in binding international environmental law agreements to varying degrees. It is referenced in a lot of case law at the international level as well, but it is not yet legally binding in the way other principles are in US or international law. And that's something that needs to change. And there's a proposal I'll be making about that. So there's a lot of information on this slide, but I wanted to put it all in one slide so you see where we've been is leading in terms of a proposal here. So the first part of this is, well, there's not going to be any protection for these voiceless communities if we don't have identified regulatory bodies that are going to be responsible for their stewardship. Otherwise, it's just going to be ignored. So the positive side of this is that future generations commissions already exist in many countries in Europe. So this is a very recent development, past 5-10 years maybe. The fact that the concept is already out there is quite encouraging because future generations are getting so much more attention just in the past year with all of the climate justice litigation going on around the world. And this is something that absolutely needs to expand both in the US and outside the US. And the reference to the sustainability mandate applies to all three of these commissions, these bodies that I'm referring to. So we'll get to that in a moment. So an animal protection agency for wildlife. So you might be balking at this for two reasons. Well, we have an environmental protection agency, but there's nothing really in the mandate of the EPA that speaks to protection of wildlife. We have the Endangered Species Act, and we have wildlife-related statutes like the Marine Mammal Protection Act. But these statutes do not apply a sustainability mandate for wildlife as a whole. It's more certain if you've got the right, if you wink and nod the right way, you're getting the right protection. If you're endangered, if you're threatened, if you're a certain kind of species, you get legal protections, and the rest, think about agricultural animals. Yeah, you're animals, but you don't really matter. So an animal protection agency built on a sustainability mandate is something we don't yet have. And an article by Professor David Cassuto at Pace Law School is starting to propose this kind of model, and it fits very nicely into what I'm trying to propose here as one of the three categories of the voiceless and leveraging protection. And then a rights of nature court. We've seen developments in this regard in many ways. So there is a rights of nature tribunal now that hears cases regarding alleged violations of the rights of nature, commonly in Latin America. Some of these other cases go on outside Latin America. We have precedent in this country for an environmental court. I know Vermont has an environmental court. There's been a lot of talk about the need for an international environmental court. So the idea of a specialized court that would address violations of protections for natural resources, nature, would be another pillar of the regulatory framework. And the advantage, again, every crisis can be an opportunity. So climate change is lurking in the background of all of this. So all of these three things would have made sense 25 years ago, but climate change makes it more of a categorical imperative. This has to happen. It has to happen as soon as possible. And ultimately, climate change is this unified threat of disruption to all three. And sustainable development can intersect with climate change in a way that's positive. And the idea here is that some NEPA cases and some environmental impact assessment cases outside the US are using this process of evaluating environmental impacts in the context of climate change. For instance, if there's a proposed coal mine, an evaluation is done, that coal mine cannot proceed because the projected climate change impacts that would follow from that proposed climate change, proposed coal mine, would exacerbate climate change to an unreasonable degree. So we're not going to allow this to proceed, or we're certainly going to at least have further discussion about it. And that's happened in a couple of cases in Australia and Canada. We've also seen NEPA case law really since the early 90s that's been evaluating climate change as one thing that federal agencies have to consider about long-range cumulative impacts of proposed projects. So this is something that needs to be advanced and leveraged in a positive way. And then there's the stewardship and rights-based piece of this. So building on that Juliana reference that I mentioned, the argument is that for this to work most effectively, governments having more of a stewardship role it has to happen at a much greater level. So what we saw in Urgenda is really an encouraging foot in the door here, that ultimately for a case like that to be successful, if that can be expanded outside of that very limited context, the notion of we trust the climate science, well, almost, most people do, half of the US does. So we trust the climate science, and assuming we do, what the science told us mandated that outcome in the Urgenda case. It should similarly mandate the stewardship responsibilities of governments involved in environmental management, because what's the point in trying to manage the environment if we ignore what is coming down the road in terms of the impacts of climate change? It's a waste of our time and resources to regulate short of what the science demands of us. And then the argument becomes, oh, but it's so expensive. We don't want to cripple our economy to address that. But it's the pay me now or pay me later proposition that is not embraced the way it should be. So yes, we avoid near-term costs by choosing economy over environment, which is a false dichotomy anyway. But the costs down the road for failing to regulate are enormous and higher than they would have been if you had proactively regulated. So that's something that has to be embraced more fully, this notion of stewardship being driven by the nature of the science and what it requires with climate change challenges. And then the rights-based approach as well. So ideally, in an ideal world, which we don't have now and never will, we wouldn't need the rights-based approach to hold the governments accountable, because they would have the stewardship responsibility and they would fulfill it. But that's not the way life works. That's not the way human nature works. It's not the way governments work. They're going to fail to meet the stewardship responsibilities that they're ultimately assigned, and there needs to be a way to hold them in check. And lastly, we have precedent from the Endangered Species Act and NEPA that we can build on to say, once we've established those stewardship responsibilities, the idea of suing to enforce a violation of those should be able to occur on the basis of procedural or informational harm. It shouldn't have to be some kind of substantive harm to an individual to say that there's been a wrong that's occurred. Ultimately, when there's a government responsibility to provide information or to engage in some kind of conduct and they fail to do so, that's going to trigger an opportunity to get into court. And then there are other ways in which the voiceless community can then vindicate those rights as well, because that brings us back to the personhood idea that we're seeing across all three, well, certainly in the nature and the wildlife domains. If nature and wildlife can sue in its own right, there's going to be more effective enforcement of those stewardship responsibilities, rather than having to have humans bring cases on behalf of the voiceless entities and only get into court if they've been harmed. Whereas if the entities themselves have the rights, it's about how they have been harmed, not the humans' harm in relationship to those entities. So those are the components of the proposal overall, and I absolutely want to give you plenty of opportunity to share your comments and questions. Thank you for your attention. Lee?
Yeah, I guess one of the starting point questions is on the rights of nature issues. Those are fairly new cases.
Mm-hmm.
I'm not sure how they've been anchored, whether they're drawing from human rights and using those as the kind of basis for extending it. What do you see as the arc of development in those cases, where they came from and where they're likely to go?
Well, with the rights of nature cases, they've been very strong in Latin America. And so what we're seeing in Latin America is that there's often constitutional or legislative recognition for these rights. And ultimately, the judicial enforcement then has some kind of platform for advancing. But we also have seen courts recognizing the rights of nature separate from an existing constitutional or legislative pronouncement about their rights. So across the board in Latin America, we've seen sometimes constitutional legislative protection, but also judicial recognition. So the India context was judicial recognition without the legislative or constitutional.
You know, are they drawing on sort of human rights-based litigation, which has kind of expanded? But there you've got the treaty base to work from for.
Right. So the theory, I think, is similar, but ultimately rights of nature is not something that is directly piggybacking off of human rights. I mean, human rights is its own domain, and rights of nature arguably was inspired by the developments in human rights law and that notion of the second of the three paradigms. The awareness of vulnerable communities and climate justice is making us more sensitive and aware of the need to protect those that have no voice as opposed to a marginalized voice. So rights of nature really took off about 10 or 15 years ago, and there's a movement, a group called, the acronym is CELDF, CELDF, and they're bringing cases all over the US and the world on these issues. And Latin America, particularly Ecuador, is considered the foundation of a lot of this thinking. Pachamama is their reference for Mother Earth, and these efforts to protect rights of nature are just grounded in the 2008 Ecuador Constitution, and it just ripple effect from there. It's really gone outside of Latin America. Australia and New Zealand are certainly going this direction with not as much success. The Great Barrier Reef is currently being considered for legal personhood protection, but Australia is more like us as far as the ability to succeed on these kinds of efforts, and so that has not yet succeeded. But as I mentioned, New Zealand was certainly a leader as well with the Wanganui River. So it's just a new area that really is rooted in other rights theories at some level, human rights and others, But we also have another domain that often gets confused with rights of nature. This isn't about the constitutional right to a clean and healthy environment. That's another domain that's occurring separately from rights of nature. So rights of nature in some way was rooted in those areas, the kind of right to environment thread, the human right thread, and it's taken off. Yeah.
So it seems like a concern with granting like legal personhood to wildlife would be like a flood of litigation, of people just suing on behalf of any animal that they're concerned about. Do you think it would make sense, or would you advocate to put any kind of like grant standing to a certain group of people to represent the animals, kind of similar to the indigenous people representing the river?
Yeah, and that's very much the kind of trajectory of the devil in the details part of my proposal. So basically, the idea here is, to the extent we're going to enable wildlife to have the ability to sue and have legal personhood, it's harm directly to them, it's not harm to the individual trying to protect them. There have to be ways to rein that in. I'm not concerned about a floodgates of litigation problem. I don't think these environmental and animal groups are abusing the process, although you'll hear that argument regularly. My concern is more about identifying the proper guardian. So that's a tradition we already have in the US. So not just anyone can walk in and be a guardian ad litem in a family law proceeding. So there needs to be some kind of process whereby proper organizations and individuals are recognized as the people who are eligible to play that role. I mean, and that requires work. And I'm open to suggestions about how that might work. But ultimately, it's not unlike organizational standing in environmental law. There's already the law already understands what it means to have a purpose and what you're set up to do, and that's something that should be recognized as that qualifies you to protect this class of entities. So I use that model and the guardian ad litem example as one way to address that concern. Other questions or comments? Yeah.
How do you think this compares in terms of effectiveness in reducing emissions and greenhouse gases as compared to, say, adding greenhouse gas emissions to the Clean Air Remedy or something like that, with working with things that are already institutionalized and not really having to change?
Yeah, I mean, and I see them as compatible. So there's no way we're going to address the climate crisis without traditional mechanisms that we are already pursuing, not effectively enough, but already pursuing. So what the climate science community tells us is mitigation is necessary, but a lot of our resources need to be invested in adaptation. I mean, regardless of our mitigation efforts, we are going to be in brace for impact mode in the next century, and we still have to mitigate, and we have to do it through the traditional means that we have been, through statutes like the Clean Air Act and through international engagement on mitigation efforts. But ultimately, this is an added value to those efforts. It's not a substitute, and it's not an effort that would conflict with those objectives. It is more of a cultural revolution of sorts, in that we're already doing something to address greenhouse gas emissions in traditional ways through our existing regulatory frameworks. Going to this model is something we're getting to, but is going to take time. So they need to proceed on parallel tracks in the right direction, and I don't see them as stepping on each other's toes.
Yeah. Just building off of that, where you're saying, this has to be a movement that we're doing. I mean, how do you think you get that into the conscious of people's minds? Because towards the end of your talk, you're saying, everyone here, obviously, in this room agrees about what the climate science says, but there is a huge portion of the American public that doesn't, and we have a president who's been saying that climate change is a hoax. So how do we get people to get to this level, create that cultural change?
Yeah, I think it's underway. And it doesn't happen fast enough, but ultimately, I'll give you two examples. It's easy to blame President Trump for a lot of things, and rightfully so. But ultimately, we were not doing what we should do on climate change in the US for 3 decades. So this is not whether we had a Democrat or a Republican in the White House. This is US. This is our population. These are the people we put into office from the people who live in this country. So ultimately, what's happening now, what the climate justice movement is doing, is that there's much more dialogue now about these issues. And politics will be politics, but ultimately, there is going to be more of an empowerment movement for sub-national efforts to be effective. California is a great example of that. So it's not all about who's in the White House and who's in Congress. That's one message of hope I would offer. And I think secondly, the dialogue itself is valuable. So I would use the example of the Green New Deal. Again, I'm a realist. I'm the one who thought our agenda was a loser. So it's skepticism helps, but sometimes you're wrong. I'm skeptical of the Green New Deal as something that is a remedy for our climate crisis. As someone who wants to see it work, I think it's unrealistically ambitious. But what's most important about it is that it's making people talk about the issue. We haven't had this conversation. In the past 3 weeks, I think there's been more national dialogue because of this proposed Green New Deal than we've had on climate in 3 decades. So that's what I'm optimistic about, that the more we hear about the science and how this is a crisis, the more the youth of our society demands we're not going to watch this happen. Things are going to start to change. And it doesn't mean we're automatically going to have forward-thinking, green-conscienced leaders in our positions of leadership at the federal and state level overnight, but it does mean that this is something that's a bit of a revolution that arguably might be our second Earth Day. And it's not happening soon enough, but the rumblings seem to be there on many levels. In ways that I haven't seen as someone in the environmental law field since I started in the late 80s. So, yeah.
How do you think, or do you think, we should address the economic issues, which is what it always kills these things? How much it costs to run these government agencies, and how much of a taking there is with the defendants in these cases? Do we just dodge it and say there's a greater good here, or do you think we have to address it?
They're inextricably connected, has to be the message. So one thing I like about the Green New Deal is that it does link those two worlds. So it is about environmental justice, and it's also about economic justice, and they are part of the same reality. So that's something that I think climate justice is showing us, that climate change initially was thought of as yet another environmental problem. It is the ultimate societal problem. It's not an environmental problem. And so talking about it as a human rights problem, talking about it as a way to empower those who are voiceless, those entities that are voiceless, makes it conveyed as a societal problem that ultimately puts the economic piece into the environmental piece, and ultimately it's something we have to be mobilized to address, the way we would be equally mobilized to say, we care a lot about national security, but we don't say, we're facing a threat of terrorism, but that's costing us too much money to feel safe, so let's just take a risk. We don't think that way in other contexts. So if we think of the imminence of a terroristic threat as justifying billions of dollars in defense spending, we need to also think about climate change as a similarly imminent threat that justifies the economic investment. And that's, again, about communication and advocacy, because most people think in terms of next week, next month, and next year. And if that's how you approach things, you're never going to see this as economically justified. And so the message about future generations is what hopefully brings more people in. To the extent you have kids, how can you not be thinking beyond next year? And it's the idea of borrowing the planet from our kids, not passing it down to them. So ultimately, that's really where the dialogue needs to be focused, because that conversation about the cost of regulating environmental problems wasn't happening in the 70s. That was Nixon's legislation, all of those acts. So it was a different mindset. It was this imperative that the environment was in crisis, pollution was a threat to public health. It was something that a bipartisan majority was able to agree on. And I think we're getting there, but the messaging is still off on climate change. That I think there's a lot more opportunity for common ground on this environment economics clash. And I've thought for years we should have been able to get a carbon tax through for that reason. That seems like the compromise answer, not nearly as ambitious as it ought to be, but it's better than nothing. And that's been a failure, I think, because of this knee-jerk partisan messaging instead of thinking about the issues. So it's an ongoing challenge. And then the other point I wanted to make about sustainable development is, you think about how could that possibly be a mandate for how we address environmental law overall. It's just too vague, it's too lofty and aspirational. And then I would remind you that we've been trying to figure out what free speech and freedom of religion mean for about 230 years, and we're still working at it. So sustainable development is in a very early stage, and yet how far it's progressed in 3 decades is pretty impressive. And I think it shows promise to be kind of an actionable standard very soon in many levels, at national levels, at international levels, that has more of a bite to it and not just merely aspiration. Yes.
One thing that really stuck out to me in the presentation was the ingenuity of identifying and labeling future generations as a protected class for equal protection purposes. And I'm wondering if we're thinking about climate policy and climate change policy domestically here through a constitutional framework, whether or not you see the Constitution as more of a roadblock or a hurdle to overcome, or a tool to add to the arsenal in order to empower and embolden this prerogative.
Yeah, we have an absolute partisan divide on that issue as well. So there's been a long-standing effort to get a right to a clean environment into the U.S. Constitution, and that hasn't happened, not surprisingly. I think what we're seeing now, though, is many more efforts outside the U.S. where constitutional protections are being built in to relate to environment issues. So we even have that in the U.S. Many states have right to a clean environment provisions in their state constitutions. So I think why the Juliana case is so significant is that I would have never guessed, first of all, the Obergefell example again, I would have never guessed the court would have found that right on due process grounds. I was thrilled that they did. It was so much easier to treat it as an equal protection case, but they're petrified of equal protection. I'm not sure why. So as a due process case, the fact that the court, with its conservative membership no less, was able to find a due process right on that issue in that way, that seems to be the gateway of something that's not too far off in the future to say there is some kind of constitutional right to environmental values. Whether that will be a stable climate, as the Juliana case asserts, remains to be seen. But just the fact that a far from ideal court was able to find a due process protection right for same-sex marriages, to me, incredibly encouraging, that we are likely going to see something reach the Supreme Court in a way that could happen in a positive light on climate change or environment in general.
On that issue, of course, there's a line of cases from the 20s on economic due process, which sort of could be used to keep government from regulating because they're impacting the ability of businesses to earn money. How do you see revival of that sort of substantive due process issue playing out? Could it also create significant problems the other way?
It sure could. So substantive due process started with the Lochner era, the economic right to contract notion that the court then was accused of pulling rights out of thin air, that it wasn't in the Constitution. The Constitution doesn't speak to a right to contract as a protected liberty. And that era ultimately came to an end a few decades later. And then as the court moved forward with substantive due process thinking, it became very much based on personal privacy and liberty interests, and it wasn't economic. But nothing says that recognition of economic liberty couldn't be found as a liberty once again. I mean, it's still possible. And so in that clash between environmental protection and economic livelihood, there's no, I certainly could see that rearing its head again as a way of pushing back against the notion of constitutional protections for environment. So yeah, it's hard to say, and that's really, it comes back to me with the role of the judiciary generally. I see the courts as a valuable tool to promote where policy ought to go with their decisions, but I don't see them as a lawmaking body. And so the reason why our courts are so active on climate change issues is because our federal government has not acted. So they are a very valuable gap filler that way. But I would be a little troubled knowing that a constitutionally protected right just is grounded in one decision because it's so easy to overturn. I mean, look at the attack that Roe v. Wade has sustained for 3 decades or more, 4 decades, and it's still under siege. And it was just that one decision that represented a constitutionally protected liberty, and any day it could be obliterated. So the right way to do this is through legislative enactments and constitutional amendments, but that is very, very hard to do in the U.S. on these issues, and it's happening more readily outside the U.S., so perhaps there might be some momentum shift in that way. Other questions or comments? Yes?
Could you elaborate on your vision for the Animal Protection Agency? Or is it your vision only in the context of an administrative agency, or have you thought about it in the context of possibly an organization or an industry ombudsman? And your role for it, is it only as a legal representative in court cases where they represent those voiceless communities, or is it more, the animal communities? Or is it more like, could it also have a role in terms of setting policy as well? So could you elaborate more on that vision?
Yeah, that's a very good question. So I start from the premise that I envision it a lot like the Environmental Protection Agency, but with more of a stewardship responsibility. So it's perhaps a bit of a hybrid of kind of like a public intervener capacity in a government entity that would be empowered to protect the interests of a certain population of people in society. So there's an environmental public intervener, for instance, and or there's a public intervener that prosecutes, that gets involved in environmental cases. In Wisconsin, they were a party in a major pesticides case in the 90s. So I see the Animal Protection Agency as being administrating issues that are involved with protection of animals, and I think the best example is factory farms. So there's a way that a sustainable development mandate can be applied to how we use animals. So a contrary example would be, if we go with business as usual, we're likely to see depletion of resources across other wildlife species that we've seen with fisheries. And that's kind of where I would want to see an animal protection agency go, as a guard against unsustainable use that's driven by science and ultimately will not allow us to be in a situation where if you eat fish, you're eating farmed fish, and 80 to 90% of the world's fisheries are depleted because we went with this take all you want and they'll always be there approach to how we engaged with that species, those stocks. So there's a lot more to it in terms of how it's like EPA and how it wouldn't be like EPA. It's a very preliminary idea at this point, but ultimately for this proposal to work, each voiceless community has to have its own steward. And so the Animal Protection Agency would function like a Future Generations Commission and like a Rights of Nature tribunal or commission as a enforcer, steward, protector of the interests of those populations. Now there's going to be a lot of details to be worked out that won't happen between now and next week, but ultimately the concept is similar to where we were in the 1960s. We didn't have an EPA, and we knew that we had environmental problems that needed a center, a nucleus of federal engagement to manage, protect, enforce threats to these issues. So granted, that was based more on a human health mandate. I mean, we have other federal agencies that engage with environment, DOI, Department of Interior, for example. But EPA did not exist, and a big part of the reason why it came into existence was the need for management of land, air, water in a way that's protective of those resources, but also a mandate on protection of human health from pollution of those resources. So there's going to be a lot of issues with how it dovetails with existing protections, and we have some of those. I would argue that the Endangered Species Act is the only one that's really working to a degree that it needs to when we talk about a lot of the wildlife-based protection laws. So yeah, that's pretty much where I am on that, and I welcome ideas and suggestions on that. Yeah.
How would that agency differ from the Fish and Wildlife Service's role in like current EPA permits
Yeah,
processes?
yeah, that's a good question. So Fish and Wildlife under Department of Interior, very narrow focus compared to what the Animal Protection Agency would be. So if we take a step back in animal law and we think about how many animals there are and how little protection many classes of animals get. So when we think about gaps in animal law, the first thing you think about is animals in agriculture, animals in medical research. And so many of these categories of animals that are receiving little to no protection under the law have to have some sort of steward for their interest. And so Fish and Wildlife, very much like what we see in EPA regulation, is a manager of tolerating a level of intrusion into these species and these ecosystems. So it's something that is not doing more harm than what's already happening, but at the same time, it is not acting with an ecocentric model in place in many ways. And so an animal protection agency would go above and beyond what is existing in agencies like Fish and Wildlife, in that that's more of a preserving the status quo in many ways, that it's meant to be managing, but it's not as much of a protection mandate as an animal protection agency would be. And it's just that concept of stewardship and how that's going to evolve, what it would mean. It's certainly not meant to cripple our economy, and it's not meant to undermine any other kinds of efforts in environmental protection, but it's a work in progress that would give more of a stewardship role for entities that cannot represent themselves.
Just really quick, you said your animal protection agency was for wildlife,
Yeah.
but now you've discussed farmed animals and animals in research and the like. I mean, do you see it as a broad? Is it only and even your book? It's about wildlife in terms of that animal community. And I was just curious, but it seems that you're envisioning it in a much broader sense. I
am, and that's a good point. And that ultimately, when I submitted the book proposal, I had animals, and the publisher wanted to use the term wildlife. I haven't really changed my focus, and that's a definitional issue that I will address in the book, that what I mean by wildlife is a broader conception. And I guess I'm going to revisit with them what was driving their interest in seeing wildlife instead of, I think I had non-human animals, and so it was clearly a broader reference. And I think there's certainly a reason, because I know they were interested in brevity, but that's one word either way. So I know there was something else that triggered that decision. So, but my conception, when I have a chapter devoted to the animals, wildlife piece of the voiceless, and that's where I'm going to be talking to them about working with that understanding, because wildlife, obviously, as you know, is a narrower conception. Yes.
Do you see any legal challenges to animals in agriculture, factory farming, on the basis of their contribution, or that industry's contribution to environmental degradation?
That's an area I'd like to see it go. So certainly there's awareness, both scientifically and in legal challenges regarding methane concerns related to factory farms. There's also concerns where with the knowledge we have of increased flooding in areas like we saw with North Carolina, to the extent we're aware of that susceptibility to regular severe flooding events, we are inviting those kinds of public health hazards and hazards to animals in the factory farms. But the connection to climate change in particular is one of those ways in which it's known as small handle litigation. So you're using an existing mechanism to challenge a concern you have that isn't regulated otherwise. So, for instance, using NEPA as a way to address issues involving climate change. NEPA is not a climate change statute. So, in this regard with factory farms and climate change, there is a lot of work now to have regulation of factory farms under the Clean Water Act, under the Clean Air Act, particularly with respect to your question under the Clean Air Act, and treat them like any other facility that is introducing things that are otherwise subject to regulation. You know, the problem in the US is very little is subject to regulation as a general matter with respect to climate change. So to the extent we are regulating those other entities, certainly one step in that direction is regulating factory farms as a facility under the Clean Air Act to the full extent of the law. So there's a lot of exemptions that pertain to those facilities, both under clean water and clean air.
Can you elaborate on what the future generations commission was, and you mentioned that it was something that you still have?
Yeah, it's very much a work in progress. So the mandate of those agencies is essentially to work as a check, and I haven't seen them working directly through a sustainability lens per se, but in essence, it is a way of being a voice of what future generations would be concerned about on many issues. They aren't environmental agencies, so whether it be with respect to economic issues, the idea is that they are a representation of what would otherwise be, you know, a youth lawsuit on a particular issue. So they are designed to represent what those future generations' interests might be when something is in short supply. So whether that be an environmental resource or something else, it's about proactively managing in a way that arguably is grounded in sustainability, but it doesn't say that. So it's much more than environmental, and it's meant to be a kind of a stewardship role that the book is very much concerned about. And so there's more that I want to look into. I know there's one in Wales, there's one in Hungary, and it's something that I'm trying to pull a little bit more from as a foundation. But that's absolutely a question that I want to have a better answer to very soon. And it's one that I welcome your input on in terms of what they ought to be doing, what they can do, what they should do as a Future Generations Commission, because it's a very broad mandate. I mean, it's just something that is full of infinite possibilities, and exactly what it does, I think, is a real work in progress, given how new they are.
Is there any viability in using public trust doctrine for, like, especially for future generations, to improve the duty on the government to maintain the atmosphere?
Yep, and that's the theory of the Juliana case. So the Juliana's the climate litigation being brought by these youth plaintiffs is a very ambitious extension of the public trust doctrine. So over centuries, we've seen the public trust doctrine evolve very gradually beyond its original mandate, which is focused on wet sands in coastal areas and riverbeds in freshwater, and with the notion that the state has the duty to manage those areas in a way for the benefit of the public. So case law over decades extended that beyond the original interests, which were navigation, commerce, and fishing, to also include protection of beach access, coastal wetlands, some wildlife issues, but extending that narrow mandate to the atmosphere is a big leap, and I'm all in favor of it, but you have to acknowledge that it's a big leap to say that that notion of stewardship that was rooted in that very narrow conception of what public trust means now ought to be applied to the entire atmosphere. So again, it's valuable in how it starts a dialogue, how we need more government stewardship on environmental issues. It might not be possible in this first effort, but the district court judge thought it was fully appropriate to survive the motion to dismiss in the Giuliani case. So that was a very encouraging opinion. I encourage you to read that, both in terms of the public trust piece and the constitutional due process argument. The trial judge was very supportive of both theories to survive that motion to dismiss. So at trial, it's going to be a lot harder if it ever gets to trial, and that's a whole other story. We've seen over a year of manipulations by the federal government to keep the case out of, away from going to trial. So, but yeah, the public trust is one of those doctrines that this whole approach is very much premised on. We need to see something that requires government stewardship beyond the degree we have now. And it is about creatively working with existing things or coming up with brand new ones and seeing what sticks.
One of my friends in Hungary, Sándor Fula, was the ombudsman for future generations, but I think that position was eliminated by the current government.
And there's someone I want to mention to you afterwards that is speaking this week who has a title with that commission. So it left me perplexed because I thought they had been disbanded as well. The Wales one absolutely is still there, and then there was another country in Europe that had one, but that reminded me that I wanted to follow up. Someone this very week giving a talk who's apparently with that Hungary Future Generations Commission.
Let's thank Randy for. Lots of sugar left on the counter.